Today's courtroom showdown isn't just another bond hearing, it's a tense standoff between second chances and a criminal past. Meet Jared Matthews, a military veteran with PTSD, now standing trial for unlawful possession of a firearm by a felon. His attorney argues for leniency, but the judge, not so easily swayed. What happens when a decorated soldier becomes the defendant? Let's dive into the drama, the law, and the fate of a man caught between redemption and relapse.
So, again, you are Jared Matthews, and Mr. Matthews, get back to my, get back where I need to be here, hold on. It's cause number 23, DCCR 1211, and Mr. Matthews is charged with unlawful possession of a firearm by a felon from September 13th of 2022. Mr. Kimler has filed a motion asking that I reduce his bond, and bond is currently set at $30,000. It looks like, is that correct?
Is that right?
Mr. Kimler?
I think it was more than that.
Yeah, it was
It's 100 is what I thought.
So it was initially set at 30. So let me see here. $100. Okay. So I wonder why.
We'll take 30, Your Honor.
Sure you will. I'm just looking at, okay, so apparently back in September of 2022, there was a bond set, and then I guess Mr. Matthews made that bond.
Then he went to custody of Louisiana and stayed in custody.
And when he got back, it was...
This is where things get complicated. Matthews claims he's been compliant, never missed court, never failed a drug test, but the judge zeroes in on his Louisiana record. That prior conviction for a felon in possession of a firearm looms large. You can feel the tension. A man trying to rebuild his life, yet haunted by his past actions. Here's the question for you. Should prior convictions always outweigh a clean record after release? Or do people deserve the benefit of doubt when they've shown progress? Drop your thoughts below. This one's a moral maze.
It was reevaluated in a bond set at $100,000. So I have and will take judicial notice of the court's file, including the probable cause affidavit, the magistration documentation that was used at the jail, and also the public safety report. Mr. Kimler, you may proceed.
Your Honor, I suppose the initial bond was $30,000, and then, of course, he accrued the cases in Louisiana, was in custody on the next court date, so was unable to make that. I don't think there's been any type of intervening circumstances from the time that he got the $30,000 bond and now that would warrant an increase in the bond other than just being out of state incarcerated.
Well, that we didn't have the public safety report system back in 2022, so I'm sure the new magistration process, that magistrate looked at the several pages that are included in that.
I'll just let Mr. Matthews address the court, then, Your Honor. He can explain his current.
Raise your right hand the best you can, please, sir. Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, go ahead.
Explain to the court what your current situation is as far as your living arrangements, where you would be residing, and what your plans are.
I still stand in charge with my mom. From when I bonded out here the first time, I never missed court. I never failed the drug test and any of it.
But you were in custody in Louisiana for something between then and now?
I caught a charge prior to the charge I caught out here.
Okay.
This is my most previous charge.
Most recent.
You're right.
Most recent charge.
And what was that charge?
It was a convicted felon with a firearm charge.
Jefferson County Parish, right?
Yes, ma'am.
And what was your sentence?
4 years.
Okay.
I was in the military 7 years. I kind of have a little PTSD. I was going to dental appointments before I got incarcerated.
All right. Anything else?
It's a 4-year offer, Your Honor.
Notice how the defense pivots here, leveraging Matthews' 7 years of military service and PTSD as a plea for compassion. It's a classic defense strategy. Humanize the defendant, contextualize the crime. But the prosecutor isn't buying it, stressing that Matthews has been repeatedly in custody and may not be reliable. This clash exposes a deeper dilemma in modern sentencing. Do we prioritize rehabilitation or public safety? And if a veteran turns to illegal possession for protection, is that a crime or a cry for help? Let's see how the court interprets it.
For Your Honor, he's wanting to try to get probation, so I would like to try to get him out, maybe to get established a little bit to show that he could come back on a contested sentencing, that he could do the probation. Is that what you believe?
Yes, sir.
Did we have a hold on him when he was in?
It was my understanding, Judge, and the reason for the offer being that obviously you see the offense date is quite
Right.
old. He should have had a hold at some point in time. I obviously appreciate his military service and will be willing to work with him on that. My problem being is that he's not a resident of this county.
Right.
Well, for
So,
Veterans Court, right? I
Right.
think we could transfer the probation.
well, I guess I mean, if he wants a probation, that's one thing, and that's up to them to offer that. If he has been incarcerated for most of this time, then we can make that. Even if we didn't have a hold, I can make a finding that we should have, and if you get that documentation on how long he was in custody there between the time of the indictment, nothing before the indictment,
Right.
but the time of this indictment and now.
We put a hold on 3/19/24.
Okay, so obviously it would need to go back if he was in custody, but I would need documentation of that. And so I don't know if that's something you guys want to take into consideration.
And that's what my notes have reflected, the credit for the time that I was anticipating we would have had a hold, because he's been in custody at least 18 months now.
Right, which, I mean,
He's asking
he would have enough time under his belt. And I understand what he's asking, but I don't know if y'all want to visit about that.
I've explained.
Opportunity.
He wants an opportunity to do probation, so.
Well, that's between y'all then. And so
Well, it
then,
could be a-
all right, back to the bond.
It could be
So,
a gap, Your Honor.
look at one more thing real quick. I mean, so here's the thing. He's obviously a convicted felon, picked up an unlawful possession of a felon over in Jeff Parish, picked up another one after that over here. So at this time, based on all of the information that I've received.
In the end, the judge denies the motion to reduce bond, citing Matthews' criminal history and multiple firearm offenses. Despite his military background and claims of PTSD, the court leans toward caution public safety over sympathy. This case highlights how prior behavior can shadow even genuine attempts at reform. So what do you think was justice served here? Or was this a missed opportunity for rehabilitation? If you found this case as gripping as we did, hit that like button, share your thoughts in the comments, and subscribe for more deep dive courtroom breakdowns that unpack the drama, the law, and the human stories behind every verdict.
Again, from that public safety report, as well as the criminal history, the facts of the case, I'm going to deny the motion to reduce the bond. You guys can visit about any options, and then we'll get it set for an announcement.
Yes, sir. I'll try to maybe figure something out.
All right, thanks.
We'll talk.